Hello, Judge. I would like to begin by reading out a statement. This case management conference is in the matter of CFI 031-2021 before His Excellency Judge Nasser Nasser and is being held by way of video conference. The claimant is represented by Khalifa bin Huwaidan Al Khaili advocates and legal consultants. Lead counsel is Asha Teresa Bijoy. The defendant is represented by Al Tamimi and Company. Lead counsel is Patrick Dillon Malone.
Thank you. We may start with the claimant first.
Thank you, Your Honor. A brief overview of the facts that is leading to the present dispute is as follows. The claimant is a UAE national and an individual customer of the defendant, and the defendant is a financial institution that is registered with the Difc and regulated by the DFSA. Sometime in June 2019, the claimant deposited an amount of 175 million with an account that is maintained by the claimant with the defendant. And in July 2019, the claimant requested the defendant to transfer back the amounts deposited. In July, the defendant transferred back the deposits, however, has retained approximately 661,000 dirhams. While inquired on this amount that is retained, the defendant mentioned that these amounts are due to charges and costs that are incurred due to early redemption from the investments. It is the claimant's position that he did not instruct or authorize any investments, and he should be transferred back the full amount. It is, on the contrary, the defendant's position that they did have the appropriate authorizations and the instructions, and they are within their rights to retain this amount. So the current case is for recovering this monies, this amount that is withheld by the defendant. As regarding the CMC, both parties are agreed to the case management bundle. The issues are already been agreed, and the procedural timetable has also been agreed. Just prior to 2 days before the case management conference, the defendant has approached the claimant with a revised case management information sheet, and with a request to include the revised case management information sheet in the case management bundle. The claimant has acceded to the request of the defendant, and the revised case management information sheet is uploaded in the case management bundle. It has been observed from the revised case management information sheet that the defendant would like to now proceed with an immediate judgment application and would like to seek directions from this court on the prospects of this immediate, on the timelines, or on the prospects of this immediate judgment application. The claimant has essentially two levels of concerns in this regard. The first level of concern, although not very highly related to the CMC, is regarding the fact that the claimant, considering the special case and involving the complexity of the facts involved, and also because of the fact that the defendant is an entity that is registered with DFSA, would think that this may not be an appropriate case in which an immediate judgment application can be pursued. Of course, the claimant do appreciate and understands the defendant's rights to pursue an immediate judgment application. However, the claimant would like to put it on record that they would think that this matter should proceed to trial, and so that all the parties would get an adequate opportunity to bring in evidence, examine witnesses, and render justice. The second level of concern that the claimant is worried about is more regarding the timing of the immediate judgment application. It is the claimant's position that it would have been better off if this immediate judgment application were to be introduced prior to the case management conference. Because if the immediate judgment application were to, ideally, the immediate judgment application should have been pursued beforehand, and depending upon the outcome of the immediate judgment application, whether or not the CMC would have been convened. But now, it looks like if the immediate judgment application were to pursue subsequent to the case management conference, the timelines that are going to be agreed today in this case management conference might not be maintainable, or all of it becomes irrelevant. So the claimant is concerned about the cost and all of the consequences and the implications that are to follow from this immediate judgment application. And it is the claimant's view, and the claimant would be grateful if the cost implications that are to follow from this immediate judgment application were to be borne by the defendant.
Thank you.
Much obliged, Your Honor.
Thank you. Thank you, Judge. The position is indeed as stated. It was just a couple of days ago that we received instructions from BNP to proceed with the immediate judgment application. And I think quite rightly, Ms. Bijoy has identified that it is an entitlement of any party to bring an immediate judgment application. And of course, the purpose of doing so in this case, as in other cases, is in fact to save costs in consistent with the overriding objective to avoid costs and time. I do take the point, and I recognize that ideally we would have had those instructions earlier. It's just simply the case that we did not. And I also recognize that the impact of our intended application will be, in effect, to put the type of timetable that we have agreed in the draft case management order in abeyance until the immediate judgment application is dealt with. But that's, as I say, ultimately, in our view, it's our client's position that this is a straightforward case. It's one that should be dealt with and ought to be determined on an immediate judgment in our assessment. And we are in a position, as we've indicated in our case management information sheet, to bring that application within 10 days of today. So we will move speedily to do so. And in relation to the question of timing also, I think, Judge, you'll be aware that there isn't any constraint in the rules on when an immediate judgment application can be taken. It can be taken at any point in the procedure. But as I've said, we do recognize that normally it would have been taken, or very often it is proceeded with before a case management conference is convened. In this case, it wasn't, but we respectfully request that the costs of today of this application be made costs in the case, and respectfully request, obviously it is the case nonetheless, that the costs, consequences of the judgment itself, of the application for judgment, would follow the ordinary rules of governing costs. So if we're successful in the application, then that's the end of the case, and costs will usually follow the event. Equally, if we fail, there will be cost consequences from that, and the case will proceed.
Now the CMC order is an agreed one, yes?
It is, but I think given that we are intending to bring an immediate, this order was agreed prior to our instructions to bring the immediate judgment application. So I think we've both indicated that it probably doesn't make any sense for the court to make a full case management order, and unless, I mean, we have indicated our intention to bring the immediate judgment application. That will then occupy the procedural timetable for so long as it takes to have that application determined, and therefore this would be redundant.
Since this is an agreed one, I will issue this case management order.
Yes.
And I will I'll issue the order, and the parties will follow the order until the defendant files an immediate judgment application. So until then,
yes.
this order will proceed. So
very good, Judge. I can see the sense in it.
I don't have anything before me that an immediate judgment application is filed, and so therefore I will issue the agreed CMC order. Following, if the defendant wishes to file an immediate judgment, they are at liberty to do so.
Appreciated, Your Honor.
Yeah.
Much appreciated. Thank you.
So I think this is the way to go forward.
Yes.
Anything else from the parties? And in relation,
I'll just check my instructions.
Yes, in relation to the cost of today's CMC, it will be a cost in the case, and the immediate judgment cost will take, as the defendant mentioned, the ordinary way for costs.
Much appreciated, Your Honor.
Yeah.
Thank you very much, Judge, and thank you, Mr.
Thank you very much.
Anything from the parties?
Nothing from our side.
Same here, my lord.
So this CMC order will be issued in due course.
Much obliged.
Thank you.
Thank you, Judge.
Thank you.
For
Thank you.